Well, good afternoon, Michiganders. It is Tuesday, March 9th, 2021, and of course, this is Tuesday with Tom, Michigan's only weekly internet show where we do answer your questions about estate planning and estate settlement in Michigan. I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in this great state of Michigan. Welcome to today's program. Well, if you haven't listened to the program for a while, you might not be aware of this, but you can now search the 200 plus podcasts that we've had about estate planning and estate settlement in Michigan. Simply head on over to the website, tuesdaywithtom.com, and use the search feature to get answers to your estate planning questions. Last week's episode, why spring cleaning should include your estate plan. You might be getting the spring cleaning bug now. It's feeling like winter is going to be slipping behind us. Spring is here. We're going to start getting ready for gardening, cleaning out our garages, etc. Well, in last week's episode, which was an archived episode from a couple years ago, I explained why spring cleaning should also include your estate plan. Today's topic, 5 things every new parent needs to know about wills. But please remember, what I'm about to discuss during the program is, as always, for educational purposes only. It is not intended to be legal advice. You need to work with your attorney to determine what is appropriate for you and your estate plan. Five things every new parent needs to know about wills. If you're a new parent, certainly you want to ensure the success of your child's future in every way, and perhaps making a will is the last thing on your mind, but it is important. If you're looking to ensure the success of your child's future, a will can be an important consideration for you to undertake. And so today, I'm going to talk about 5 key points that every new parent should know about wills. Let's start with number 1. Naming a guardian, could be the most important part of your will. We'll hear this all the time. Amanda and I will be meeting with a young couple with a new baby, and oftentimes they will start out with, we don't really know that we need to do anything because we don't own anything. Well, let's think about this. If you die while your child is a minor, the most important issue that you need to address is who will assume the responsibility for caring for your child. So for many, many young parents, it's not what you own that is the most important consideration. It's in fact that you need to think about and you need to nominate the person or persons who will raise your child. In Michigan, if you don't name a guardian, if you don't get around to it, well, the probate court is going to decide that for you. And it might be, though, that the probate court isn't going to pick a person that you would choose. So it's the most important thing that a young parent needs to do, and that is to select the person who will raise their child until they get to be an adult. Number 2, name a personal representative who you trust. Well, think about this. Somebody is going to be managing the estate for your minor child. That's a person in Michigan called a personal representative. Other states, it's an executor, but here it's a personal representative, and that is the person who will have the responsibility for carrying out the instructions that you provide in your will. So make sure that person is someone that you trust. Now, many are going to choose a family member. That might be the person that they trust, but it's also acceptable, if you don't have an appropriate family member to work with, to consider a trusted friend, to consider perhaps an attorney, to consider a financial advisor, but you need to make sure whoever it is a person that you trust to manage the estate for your minor child. Number 3, named beneficiaries on your financial accounts may override the will. And this is one thing a lot of new parents don't stop think about. Quite frankly, a lot of clients, irrespective of age, oftentimes don't think about it. Many accounts that you might have today could have a beneficiary on them. Bank accounts, investment accounts, IRAs, 401ks, things like life insurance, all of these different types of assets that you can have a beneficiary on. And when you die, the funds that are in those accounts are going to go where the beneficiary designation says they go, even if that's different than what you say in your will. So if you're creating a will and you want that will to take care of your minor child, or perhaps you already have a will and you're simply going to amend it to add a minor child into the beneficiaries under your will, make sure at the same time you are reviewing your investment accounts, bank accounts, IRAs, etc., to be sure that all of those match up with what you're attempting to do under your will. Because, again, if there's an inconsistent between them, and it happens all the time. For example, someone will come to us and say, I had a beneficiary put on my account before I had children. And now I have children and I want the estate to go to my children. Well, then you need to make sure that you're changing the beneficiary designation. Because let's say you had designated your brother. You didn't have anybody else that you wanted the account to go to. And now you have a will, and in the will you say you want the accounts to go to your children. You need to change that beneficiary designation from your brother to make sure that that account will in fact go to your children. Number 4, when you're naming a child as a beneficiary, remember that a will only goes into effect after you die. Number 1. Number 2, if your will leaves property outright to a minor child, in Michigan, the probate court is going to be required to appoint a conservator who will manage that account until your child turns 18. But when they turn 18, essentially they can knock on the conservator's door and say, "Give me the money." You need to think about that. Do you think that at age 18, your minor child, who's now an adult in the state of Michigan, is going to have the maturity to handle the estate that they're going to be receiving from you? Are they going to spend the money to go to college, which perhaps is what you want them to do? Or will they be influenced at an age by other people, or perhaps simply their lack of maturity, by which they will be making bad investment decisions? So a will might not be enough. Example, a trust. A trust goes into effect when you create it, number 1, so it avoids probate. And 2, it can provide a structure to manage assets that you leave behind for your child until they're a more mature age, perhaps when they get to be 25 or 30 or whatever age you determine is appropriate. So a will might not be the best document. It's still going to be an important document because that's how you're still going to name the person or persons who will raise your child, who are going to be the guardians for your child. But when you look at what you own and how you want it to be managed for the child, and if you want it to be managed beyond age 18, then you need to look at a different sort of arrangement, which is what a trust is going to provide for you. And number 5, in the absence of you doing anything, the state of Michigan has a plan for you. Think about it this way. A will is really an instruction manual for your personal representative and the courts to follow. You need to be clear and consistent in stating what your intentions are for your child. But if you're not clear, or if you don't leave any instructions at all, i.e. you don't have a will at all, then the probate court is going to follow the government's plan for you. Lawyers call that intestate succession. And that plan might not be what you wanted for your child, and it might subject your estate to unusually long delays, even if the plan is what you would want for your child. That's why it's important that you do have a plan, that at a minimum you do have a will, so that your personal representatives and the courts will have the instructions that you want them to follow. So let's briefly recap again the 5 things every parent needs to know about wills. Number 1, name a guardian could be the most important part of your will. Number 2, name a personal representative who you trust. Number 3, named beneficiaries on your financial accounts will override the will. Number 4, a will is not always the right document to accomplish your goals for your child. And number 5, in the absence of instructions, the state of Michigan will determine what will happen with your estate and will also determine who's going to raise your minor children. So providing for your child's long-term welfare, maybe it's going to start with a simple will. Maybe that's going to be appropriate for you at this time because most important is to have that guardian appointed. But you might likely need more than that, either now or as time goes by. And that is certainly something that Amanda and I could talk to you about, could help you determine what's the best plan, what's the best strategy to use to accomplish the estate planning goals that you have. Of course, Amanda and I would be honored to have the opportunity to help you protect your loved ones, including your minor children, by putting together your estate plan, perhaps amending a plan that you already have, or assisting you in settling an estate. And there are a number of ways that we can do that. Again, because of COVID, we are not currently seeing people in person, but much of what we are then doing is being done through our website. So if you go to doylelawpc.com, click on the virtual office tab, and you're going to have some options under the virtual office tab. 1, prospective clients. You're not already a client of ours. We have information there on how we can work with you using Zoom or telephone in order to put together or update an estate plan for you. If you're a current client, you're going to see again at the virtual office, we have our Update My Plan service that you can use to request updates to the plan that we've already prepared for you. And for anybody, whether prospective clients or current clients, if you simply have an individual document that you know you need to do, maybe you need a certificate of trust, or maybe you need a healthcare power of attorney, I invite you to take a look at the legal store that's available on our website, and you can order, not download, but you can order through the legal store individual documents for either creating or updating an estate plan that you already have. Well, I think that's gonna be it for today's show. As always, though, if you have a comment about the program, a topic that you'd like to have me discuss, or questions that you'd like to have answered, please send me an email, tom@tuesdaywithtom.com, or mail me a postcard, Tom Doyle, P.O. Box 16066, Lansing, Michigan, 48901. And as always, we invite you, your friends, your family, follow us on Facebook and Twitter. That would be Tuesday with Tom. Follow the office as well, and that is Doyle Law PC. Reminder too, Tuesday with Tom is available on many platforms besides just the Tuesday with Tom website: Apple Podcast, Spotify, Google Podcast, iHeartRadio, Spreaker, and others. And as always, you can always ask your smart speaker to play Tuesday with Tom. Well, thanks again for spending some of your Tuesday afternoon with us today. I hope that you have an awesome day and an awesome week in Michigan. Stay safe now. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.